Stanford University.
Good afternoon and welcome to the penultimate EE 380 for this academic year. Just a reminder for those of you who didn't remember to bring your towel, today is Towel Day. For those of you who are confused as to why it's Towel Day, you should go back and read The Hitchhiker's Guide to the Galaxy. It's one of the two things you need to have to navigate the universe. The other thing is, of course, the book itself. Next week, we have the creator of Scala coming in. I'm not going to attempt to pronounce his last name. I've managed to mangle it far too often. But he's going to come and describe Scala, which is, depending upon who you talk to, yet another programming language, a compendium of many interesting features, or the successor to Java. Today's speaker is Pam Samuelson. She is a professor of law at the University of California at Berkeley. She's on the board of EFF and EPIC, two of the most significant organizations around these days. And she's going to talk to us about the Google book settlement and tell us a little bit about the reason why there is a settlement, I suppose, and why it's important. Books really capture the knowledge of the entire world, and making them broadly available has been a goal of many people, including Google itself as an organization. And there have been some interesting legal machinations that come along with that. So with that, Pam, you're on. Thank you.
Thanks, and thanks for coming today. This is my favorite subject, so it's always good to have some people to talk to about my favorite subject. Here's a kind of overview of where we're going today. I'm going to try to go through the first part pretty quickly, but I think it's actually important to sort of ask ourselves, why did this project get started in the first place? Why did it attract legal challenges? Why did it settle? And then why did the settlement fall apart? And what are the options going forward? Of those, which is the most likely and which one would be best, which isn't necessarily the same thing. Okay, so all of you know that Google has been scanning books since 2004. Uncontroversial part of the scanning project is that about 2 million books are part of the Google Partner Program, and copyright owners have said yes to allowing those books to be scanned. So they're not going to be the focus of our attention, but it is to say that the Google Books project isn't just about the controversial part, it's also about the other part. I don't have much to say about the uncontroversial part. It's the controversial part that kind of got my engines going. So of the approximately 15 million books that Google has said that it has scanned so far, about 13 million of them came from the library partner institutions, and as I understand it, Google is continuing to scan books like crazy. It had the vision and the technology and the financial resources to do this kind of project. Of course, it didn't have the books. So if it was going to try to have a collection, a database of these books, it had to find partners to do that. And a number of institutions of higher education, including Stanford, agreed to allow this. And they had some motivations for participating in it that overlapped somewhat with Google's, but also were somewhat different. One of the things you really got to give Google credit for is that when it came to the copyright obstacle to scanning the books, they were willing to go for it. The libraries, on average, were a little more queasy about it, particularly those that are private institutions, because of some queer things about the 11th Amendment jurisprudence of the U.S. Supreme Court. State-related institutions are immune under current interpretations from damages liability, from any kind of monetary compensation. So while it would be possible to sue one of the state-related institutions, such as University of Michigan, for infringement for providing Google with the books to scan, all you'd get is an injunction, and so they weren't so much the target. So Google had a number of motivations to engage in this book scanning project. Of course, their motto of they want to make all the world's information available to the world is something that was a motivation, but they had to do things like scan, index, and then try to make other kinds of uses of it. The computational uses of trying to sort of use the contents of books in order to improve their search engines and to improve automated translation tools was, I think, a pretty important motivation for the project. And of course, they were serving snippets in response to user search queries. And I think, although they've not said it, that they had in mind also to do some building of services to process text. Yeah?
Are you omitting the most
Excuse me?
Are you omitting on this slide the most obvious kind of motivation, which I guess you mentioned, but it's not written down, which is to make a huge digital library of all the world's books? I mean, that to me seems like the obvious reason why.
Well, I have actually that as the last thing, and it's a question mark. So yes, they wanted to do the sort of the database of books, but
this isn't a library. I mean, I think they wanted to create a library that's different from licensing. But
well, you know what? If that was their motivation, it's probably a good idea that they didn't say so publicly because it would undermine their fair use defense. I'm going to talk about that in a minute.
that's their motto.
Well, okay. I'm just saying. Okay, these are the things that people have been talking about in the sphere I operate in. And the question about whether, in fact, they intended to make a kind of digital library of all the books and then to find some ways to make all those books available to the world is something that I've not seen a public commitment that direct about. Okay. So libraries had some similar motivations but have some different motivations. And so one of the things that libraries are concerned about is that books are falling apart. They want to preserve their collections generally, but also they want to manage their collections. As we all know, our students today expect everything to be available online, and they don't want to go to the bookshelves that we might have grown up with. And so to manage collections more efficiently, it would be nice to have these books available online. But the initial Google project was not being sold to the libraries so that they could do that because there were seen to be copyright obstacles to that. So the focus then has been on preservation, on management of information, and I think that non-consumptive research, at least during the period when the negotiations with the libraries were happening, the idea that scholars and other researchers could use this corpus of books to engage in searches across books that are impossible to do if you do it on a book-by-book physical book basis was something that was important. Also, improving access to books for print-disabled persons was something the libraries cared about quite a lot. And to the extent that they could lawfully make contents available, libraries were motivated to do that too. As you know, public domain books are available now. Google displays snippets of most of the books, but at the moment, the corpus as a whole is not sort of displayed unless the rights holders have given permission or Google has decided the book is in the public domain. Google was well aware of the copyright risks from the get-go about this. The copyright law gives the copyright owner the right to control the reproduction of their work in copies. Scanning a book is a reproduction of it, and so it was something that was always kind of out there as an issue. Google thought it had a fair use defense to this claim. And I'm going to spend just a minute on the fair use defense, because now that the settlement has failed, one of the possibilities is it goes back into litigation, and so you might want to have a sense about what the fair use argument kind of looks like, because this is not something which might be obvious on the face of it. So the Authors Guild and the Association of American Publishers have made an argument that this is copyright infringement and not fair use at all. And there are 4 factors that typically are considered in a fair use determination. What is the purpose of the defendant's use? What is the nature of the copyrighted work? How much is copied, and whether there's harm to the market for the work or the potential market for the work. So from the standpoint of the publishers and the Authors Guild, Google has a commercial purpose for doing this. They're not transforming the work in any way, making, for example, a new work that transforms some of the expression from the first work. They're making systematic copies of every kind of copyrighted work that's out there. They're copying the whole thing on a systematic basis and storing it permanently, and giving copies to library partners. And all of these activities kind of together make the sort of the how much did you copy thing a big factor in the case. And then from the standpoint of what had been traditional copyright law, you presume harm from a commercial use. And they had ideas also that there was a risk of loss from inadequate security. If a hacker basically was able to get in, that all the books would be then available on the internet, and everything would go bad. The Google's perspective on fair use is pretty much diametrically opposite of that, not surprisingly. So one of the purpose of the use, as Google conceives of it, is not commercial, but rather promoting better access to information. And it's important to realize that there were a number of cases that had been litigated at the appellate court level, allowing search engines to make copies of things in order to provide access. So little thumbnail images, for example, had been challenged as an infringement, and the Ninth Circuit Court of Appeals, which is the one in which we sit, said that making the thumbnails was actually a positive thing and was a fair use. So, and one of the reasons was because it promoted better access to information. The argument also from Google's standpoint is that in order to make snippets available, which they think is fair use, you got to copy the whole thing, because otherwise you can't make snippets available. You'd only be able to make a little bit available, and you want to make snippets that are responsive to queries. And to the extent that many of the books that are in especially research library collections are ones that are older books, the publisher may no longer exist. It's hard to know who the copyright owners. Many of the books are considered to be orphans, and I'm going to talk more about the orphan work issue in a little bit. Although they're copying the whole work, it's only snippets that are being available, and a few short snippets that are available, not enough to allow you to read the book and to essentially get all the sort of the content without paying for it. They argue both that Google's book search enhances the market to the work, because when they provide snippets, they also provide a link to places where you can buy the book, and so that's not going to harm the market to the book, for the book. And if you don't like it, if you don't want your book, for example, suppose it's a dictionary, snippets might actually give more of the expressive content, and so if you don't want to have your work basically part of the snippet providing, Google has said that it will say no. They also have an argument based on market failure that it would be prohibitively expensive to try to clear rights to the books on a book-by-book basis for all these books that are in library collections, and so their argument is that this is a fair use. I'll tell you that the overwhelming majority of academic commentators on the Google book fair use defense would say that actually it looks like a fair use to us. But of course, that's law professors and not necessarily what judges would decide to do. But Google has reason from the search engine cases to be at least somewhat optimistic. So you can see that with these two diametrically opposed positions about sort of the fair use defense, which was the only real defense in the case, that there's motivations on both sides to settle, right? The publishers and the Authors Guild basically don't want Google to win a fair use defense because they think that would let the floodgates of scanning activities happen, and they are definitely not happy about that prospect. But litigation is also really expensive. It takes a long time to do. I would say that if this case goes back into litigation, it's never really been in serious litigation, but if it went into litigation, we're talking 5 to 10 years before, I think, before all the issues would be resolved in the courts, and that's just a lot of time, and the Authors Guild lawyers taken this on a contingency fee basis, and so, you know, he was expecting to get $30 million when the settlement was approved, and now he's facing 5 years at a minimum without any money coming in, and so that's kind of a motivation to settle, I think. Google had a motivation to settle, at least if it could get certain kinds of terms, because it too wanted to kind of get on the other side of this litigation, and but something that would be less apparent to all of you is that if the Authors Guild and the AAP won their respective lawsuits, that Google was facing a potential statutory damage liability in the neighborhood of $3.6 trillion, and that's a lot of money. And so why is that? It's even though scanning a book for the purpose of indexing its contents and making snippets available causes virtually no harm to the copyright owner whatsoever, copyright law, in its infinite wisdom, allows the copyright owner, if they win, to get at a minimum $750 per infringed work, and the range goes up to $150,000 per infringed work if the infringement is willful. And so to the extent that the publishers and the Authors Guild were arguing that this is willful infringement, for Christ's sake, we're talking in the sort of trillions of dollars, and this is just one of the quirks of copyright law in the United States of America today. But you can see that that's a kind of motivation that might actually have been somewhat significant. And there was, as the proposals got refined, an opportunity for a win-win win here. So Google, the Authors Guild, the authors and publishers would have a new source of revenue, libraries and the public would get access to books, and so it seemed like a win-win-win all the way around. Core of the settlement, again, I'm not going to take very long about this, was $60 per book to the people whose books had already been scanned by Google, and then the opportunity to participate in the commercialization effort that Google was going to undertake, and the share for the copyright owners out of whatever Google made from these commercializations would be 63%, essentially thrown over the wall to this newly created collecting society, the Book Rights Registry, and then BRR was responsible for getting the money to the right people. Google just didn't care about that. All they wanted to do was get the money that's theirs. So the settlement is basically was about out-of-print books. So it's not that in-print books are irrelevant, because one of the things that the settlement would have allowed is what the settlement calls non-display or computational uses of of the books, even the books that are in print. But the commercialization that Google was authorized to do had to do with out-of-print books. And if the book was out of print, Google could make what the settlement called display uses of the content. That included all manner of commercialization and also 20% of the contents in response to queries. There were 4 sources of revenue identified in the settlement. One was the fees from institutional subscriptions to institutions of higher education and many other sources. This is the ISD that I mentioned a little bit ago. You could also purchase these books in the cloud through the consumer purchase model, and there would be printout fees from public access terminals in public libraries and in institutions of higher education. Libraries really were very excited about the possibility not just of being subscribers to the ISD, although all of them were expecting to be subscribers to the ISD, but they'd also get back a library digital copy of the books that were scanned from their collection, and they would have the right to authorize students and faculty to engage in this kind of non-consumptive research that I talked about before, and to provide print-disabled access to the LDC books, and that's really cool. Also, public libraries would be eligible to get 1 terminal each that would have access to this institutional subscription database, and then other libraries and the like could subscribe if they wanted to do. So lots of reasons why the settlement made some sense. It removed liability. It would have allowed much more public access to books. Revenues would have flowed to authors and publishers who registered, giving new life to old books, and lots of other good things. The question that the judge was faced with was not whether this was a really good deal for everybody. Rather, the question that was before the court was whether or not the settlement was fair, reasonable, and adequate to the class on whose behalf it was negotiated. Now, I can get into the minutia of Rule 23 of the Federal Rules of Civil Procedure if you like, and I've written a whole article on it, so I know something about it, but I know you don't want to know that. But that's the question that was before the court, not whether this is a good idea, not whether this is a kind of fair compromise given that people have different perspectives on things. Rather, the question before the judge was whether it's fair, reasonable, and adequate to the class. And in order to allow them to decide whether this is fair, class members to do it, you have to give them notice. So after the announcement of the settlement, there was then notice mailed to as many people who own copyrights in books as Google could find. 6,800 people decided to opt out of the settlement, and thousands more objected to it on a wide array of grounds. And again, I'll talk about that in a second. The hearing about whether or not this was fair was held in February of 2010, and a little over a year later, the judge finally ruled on it, saying no. So he identified 6 key problems with the settlement. The first, and I think most significant, is the scope of the settlement in relation to the issue that was in litigation, and I'll explain that in just a minute. But there were 6 categories of things that, in his opinion, explaining why he was rejecting the settlement, were actually his explanation for it. So what is this scope of the settlement versus issue in litigation? I think a nice statement by the Department of Justice spokesman at the fairness hearing kind of gives you a nice flavor of that. What he said was, it is the duty of class counsel to litigate the claims they brought or to settle those claims. Okay? you're not supposed to use litigation as an opportunity to engage in restructuring of the market for everybody else who isn't there, and to engage in essentially quasi-legislative activity. And so the Department of Justice said that the key parts of the settlement are not about whether or not Google has a license to allow snippets to be made available, but rather to commercialize the books. And Google, if it started out with the intent of creating a digital library of books, there could be no conceivable fair use defense for that. So that issue was not in litigation, and therefore settling this lawsuit by allowing the commercialization is what the DOJ called a bridge too far. And so it really had to do. Another way to think about it is that the federal rules of civil procedure are not supposed to be interpreted in a way that modifies substantive rights of the parties in ways that are, again, not things that are in litigation. So it's hard not to look at the settlement and say it modifies the substantive rights of the copyright owners whose out-of-print books are actually going to get commercialized. And yes, you can show up and say no, but the default rule of copyright law is that you got to get permission before you commercialize somebody's work. That's just the baseline. And so DOJ basically said that the judge didn't have power to approve the settlement. Now, notice this is actually not about the fairness, in some sense, of the settlement to the class. This is really a kind of procedural sort of like what can courts do and not do, and that was a really important thing. And so the major thing that the judge perceived was that the settlement would essentially be equivalent to legislative reform to allow the exploitation of orphan books. Orphan books being books that where the rights holder can't be found after a reasonably diligent search, and the older the book is, the more likely it is to be an orphan. And the consensus among the people who were discussing all of this was that a substantial part, and perhaps even the entirety, of the institutional subscription database would be made up of books that rights holders had not claimed. Yeah. I'm sorry?
I missed the connection between the class counsel, Google, and the judge and the Department of Justice. How were they involved?
So the Department of Justice announced in April of 2009 that it was initiating an investigation into the settlement. The initial investigation was to consider whether the settlement was an antitrust violation. And the judge asked the Department of Justice to weigh in on the settlement a week before a week or two before the fairness hearing was scheduled, so that the judge could have the benefit of their thoughts. The first time that they weighed in, they said, yeah, you can't do this. And the surprising thing is, although they rested much of their objection to the settlement on antitrust grounds, they also decided to weigh in on what I'm calling the kind of class action grounds, right? Rule 23, this is something you can't do, and there are sort of problems with it from this procedural standpoint. By the time the settlement was then withdrawn, there was a new amendment to the settlement in November of 2009. The Department of Justice once again looked at it. Google and the settling parties thought that there was going to be that they'd addressed the concerns that the DOJ had raised, and in fact the DOJ came out even more strongly against the settlement the second time than the first time. So DOJ, it can weigh in on litigation where it believes that there is some public interest at stake that the parties don't have an interest in, surfacing. You see, while these parties, Google on the one hand and the Authors Guild and publishers on the other hand, were completely at odds during the litigation, by the time they get before the judge in the settlement, they're like best friends, okay? And so there's a kind of, nobody's an adversary anymore, except perhaps the objectors and or some public interest organizations, or in this case, the Department of Justice weighs in and says, do or don't do this thing. So the settlement would have created a regime for commercializing the orphan books through the ISD, and the settlement had ideas about what to do with the money that was owed to rights holders that wasn't collected. The first one, I'm mentioning this just because it rankled me the first time I heard about it, and it still rankles me, so I like to share it, okay? So they had this idea, which is that if all these people didn't show up, then all the registered rights holders should get the money that was owed to these other people for books that they didn't write and in which they own no rights, okay? It's a nice windfall, you know, to participate in the project, and the Department of Justice said that creates a blatant conflict of interest. So the revised settlement changed the rules and was going to appoint an unclaimed fiduciary, but after 10 years now, the settlement funds would go to literacy charities, and I wasn't nuts about that. In any event, the kind of related to this question of what can you do through a class action settlement? How big is the scope of the things that you can do in a settlement as compared with the issue in litigation? Part of what the judge was concerned about, and this is also something the Department of Justice was concerned about, is this looks like legislation, right? It's quasi-legislative because it's going to change the default rules, but it's only going to change the default rules for Google, and it's not going to change the default rules for anybody else. So orphan works is something that's been pending before Congress before, and that's something that the judge said that's got to be done by a different branch of government. Okay. So a second category of problem that the judge saw with the settlement was the adequacy of representation. So it is the duty of class counsel to represent all of the members of the class, not just some of them. And if there's a perceived lack of fair representation of the interests of some of the affected members of the class, then that's a reason to say that the settlement cannot be approved. I made 2 submissions to the court making some arguments that the Authors Guild had not adequately represented the interests of academic authors based on my own judgment and the judgment of other academic authors that I know. If your book is out of print and it's an opportunity to make it available in a digital library, you'd rather do it for free rather than to go through the commercialization. And so open access preferences of academic authors were not respected, and actually the AAP and the Authors Guild gave me a gift in their final brief to the judge, because I had been saying that, you know, we academics like our works to be available on open access basis, and they actually said in their brief that the interests of open access advocates are plainly inimical to the interests of the class. I'm going, thank you. So before the judge, I actually used that line. And not only had they used those words, plainly inimical, they italicized them to emphasize just how antagonistic they were. Somebody should have been fired for that particular thing. Anyway, so Judge Chin, a little bit to my surprise, actually found the adequacy of representation problem troublesome. This has ramifications potentially, again, if the matter goes back into litigation. You can't get a class certified if there is divergent interest within the class. And so a second defense for Google, if this case goes back to litigation, is that you can't certify the class. If you can't certify the class, then only the individual authors or publishers can sue. And of course, the money that can be had for settling a case like that is quite different than if you have a class that's certified. The judge also found merit in the antitrust arguments, although it did not give a very thorough analysis of the antitrust issues and ignored actually several of the points the Department of Justice had made in its submissions to the judge. Focused on two things, though. One is the notion that Google would get a de facto monopoly to commercialize these out-of-print books, including the orphans, and that was something that no competitor could match that, at least not without some legislative help for the other guys. And again, a surprising thing that the judge said was that approval of the settlement would entrench Google's monopoly in the search market because it would be able to answer tail queries better than other search engines. And Yahoo and Microsoft, you won't be surprised to find out, had objected to the settlement on the ground that it was unfair in that particular way. And the judge basically found some merit in that. And I think if you take that seriously, then the implication would be that Google should have to license the other entities to, I know, I'm not holding my breath either, okay, but I'm telling you that the implication of that would be that there would have to be some licensing of the corpus for uses by other search engines. And again, I'm not saying it's going to happen. I'm just saying when the judge made that particular statement, it was opening up the door to that particular kind of remedy.
There's no way to identify the improvement in the search technologies. And the damage to Microsoft and Yahoo is not limited to Google's improved search technology. There's also damage to their market share in the advertising network.
Thank you for that amendation. Okay, a fourth category of problems, yeah.
Wouldn't that advantage to Google also exist if Google was to win the lawsuit, though?
I'm sorry?
Wouldn't the conditions be the same if Google was to win the lawsuit? Because their search results would still be improved in the same way.
Well, so again, if the matter goes back into litigation, there's no reason why the Department of Justice couldn't come in and make an argument that that actually, you know, that this now monopoly that they would have over the corpus of books. Google's response to that has been, and I think would be still, anybody can do what we did, and as long as in fact it's, I know it's not really true, but it's a good line, okay? But it would be their first line of response if, if the scanning is found to be fair use, then it would be fair use for other search engines to do the same thing. There are other obstacles here, and I'm not going to get into it unless you ask a further question, but that's kind of what's going on.
There's another question here. What's the definition of a search engine? I asked that question because I used to be in the business, and there's a guy who runs a search engine out of his garage in Texas, makes several $100,000 a year running what looks an awful lot like a search engine. So does he get the copy too?
Well, so one presumes that there would be some criteria set up no, because if it's challenged by the Department of Justice, okay, they are either going to get a consent decree, they're going to lose, or they're going to get an injunction. And it would be the fine details of the injunction that would work out sort of who would be entitled to access under what kinds of conditions. I'm not saying that this should be available to everybody and for free. I'm saying that the implication of that part of what the judge said is that some forced access would be in contemplation. That was my only point.
I'm just pointing out that the definition of search engine is much more broad than I think anybody realizes.
Yep, I'll take the point. Fourth category, a problem that the judge had with the settlement had to do with reader privacy. The settlement was about 300 pages long and contained many provisions that called for Google collecting very, very, very fine detailed information about user usages of books in the corpus. And there's almost nothing in the settlement agreement itself that addresses user privacy. Google, in response, said we'll apply our usual privacy policy, and I have to say the privacy advocates did not find that to be particularly acceptable. And so there were probably 5 different submissions to the court raising reader privacy concerns, and it resonated with him. Again, I was a little bit surprised by this. Judge basically said that by itself, this was not a reason to deny this or to reject the settlement, but he found it troubling, and he hinted that if there was going to be a future settlement, that the future settlement should address reader privacy more than this one did. I'm going to move on because and I'll come back to your question. The 5th and 6th objections that he found to have some merit actually are not really all that separate. Both of them are copyright objections, although one of them has to do with whether or not the settlement violates international treaty obligations of the United States. And again, for your purposes, I'm going to spare you that one. But the part that you probably can relate to a little bit more is that the judge found that it was fundamental to copyright that the default rule is that reusers have to get the rights holder permission before they commercialize, not let them sort of say no to commercialization later. And he quoted at some length from some of the objectors about their the shift in the default rule from an opt-in, ask me first, to an opt-out, come forward to ask me to stop. So what are the next steps that are possible? One was an appeal, but the period of time in which an appeal could be lodged has actually passed us by, and so that option is off the table. I think that was a wise decision because the Second Circuit Court of Appeals, before which this would go, has some precedents which, again, for reasons which I'll spare you, make it unlikely that the Second Circuit would have approved it in its current form. A second option is a revised settlement agreement, and the judge made very clear in his opinion that that's what he wants, that's what he prefers, that's what he expects, and he has said that he wants it to happen, and he's holding on to the case. Now, part of what's interesting about this is that while this case was pending, he was nominated to the Second Circuit Court of Appeals. He was, at the time he took the case at first, a district court judge, and he's now been elevated, as they use the term, to the Second Circuit, but he's sitting by designation as a district court judge for the purposes of reviewing this case. In other words, he likes this case, he wants to hold on to it. And so, you know, if it goes back into full litigation, I don't know that he's going to be able to do that, but at least for now, until he sees and tries to cajole the parties into a new settlement, he will be holding on to it.
Has his promotion been approved by the Senate?
Yes, it has, actually. He's been sitting actually since, I think it's about May of last year. So part of the thing is all of us professor types were saying he's certainly going to get rid of this case really quickly because he wants to go to the Second Circuit. And so it was kind of a surprise that it took 13 and a half months to do. Okay, a third option is resume litigation, and again, that's a possibility, but I'll tell you that my conversations with the parties have suggested to me that the Guild and the AAP really don't want to go back into litigation. Again, it's 5 years of lots of high expenditures, some non-trivial chance that you'll lose, and, you know, that's kind of a big deal. And so, again, the class certification issue would probably be the first thing to be litigated, and it's not clear that that could happen. So legislation is the fourth possibility. What are the prospects for a new settlement? Again, it's hard to read the tea leaves here because the parties are not being particularly forthcoming. Obviously, they want to talk it over and reach some agreement before they make public statements about it. But one of the things that's very interesting is that at the fairness hearing, both Google's lawyer and the Authors Guild lawyer made statements to the effect that there will be no settlement unless it's an opt-out settlement. Okay, what I mean by that is Google gets a license to do whatever it's going to be able to do with all the books, and you can opt out of it if you want to, versus you have to opt in. So the Department of Justice and the judge signaling to Google, I want an opt-in settlement, and Google has said no, but of course that was then and this is now, and so they might actually change their mind.
How do you deal with the orphans issue?
Well, what happens with an orphan, I mean, what happens if there's an opt-in regime is that Google doesn't get a license to the orphans. Okay? Now, that's not entirely true. Here's my scenario. My scenario is that there are actually about 5 or 6 different licenses that the current settlement would have given Google. 1 is to scan the books, 2 is to index them, 3 is to make certain kinds of display uses of them, 4 is to make non-display uses of them, 5 is to make non-consumptive research uses of them, 6 is to give a library digital copy to their partners, and 7 is to commercialize. I would think that Google might be happy to settle if it could get an opt-out for all of these and only an opt-in for commercialization. Okay, because then they could use the book for the computational uses, etc. Okay, so that would to me be something that would be attractive to them even on this. But what it would mean is that if you want to make the orphans available, you got to go to Congress or you got to find some other way to do it, because the judge has made very clear, very, very clear, you can't get a license to commercialize the orphans through this process.
Would this lack of commercialization strengthen their fair use claim?
It might.
The problem with that solution is, of course, that the percentage of books that are orphans is fairly large, particularly because the duration of copyright was extended and then extended again, and the Mickey Mouse rule, which compounds the problem. If the term of copyright were reasonable, on the order of 14 years or less, say,
Founders
would be
copyright.
less problem.
Yeah, I agree, absolutely. And so, you know, one of the things that I sort of, when I talked about the options, right, one of the options that I didn't really talk about is the lawsuit could go away, right? The publishers, instead of having a class action lawsuit, they could just settle with a small number of people. And so then the status quo would be that Google has these however many millions of books. My guess is it's closer to 20 than 15, but I only go with stuff that's been made public so far. And they're probably going to try to go to 50. At least that's what some of the statements before the court had suggested. And so, you know, Google's continuing to scan. It's making the library digital copies available to its library partners. It's making these non-display uses. It's encouraging non-consumptive research by scholars and serving up snippets. You know, the world is not a worse place, in my humble opinion, if that's what we end up with. And of course, part of what's happened since the settlement was announced in October of 2008 is that the ebook market has gotten much more robust, and there are now initiatives partly spurred by the Google Books project, both in the United States and elsewhere. So Europe has a digital library type project, Europeana, that they're promoting. Japanese Parliament has decided to digitize the books in its collection. There's talk about a Digital Public Library of America initiative here that would try to approximate some parts of what the Google Book settlement would do. But it's fair to say that the failure of the settlement means that there are some benefits that we won't get, at least not anytime soon. This institutional subscription database of millions of out-of-print books would be a really nice thing to be able to have. I'm less thrilled about the consumer purchase model because I don't like this books in the cloud thing, but that's me. Also, there would have been more display of these out-of-print books contents in response to search queries. Public libraries would have had access, disabled people would have had more access, and some disputes between authors and publishers would have gotten resolved through the settlement. So there are some losses for the rejection of the settlement, and my current work project is to try to imagine what would a legislative package look like that would achieve the objectives, the positive objectives of the settlement in a way that would not have the downsides and not sort of be a misuse of the class action settlement process the way the Google settlement would have done. So I'm happy to talk about the component parts of it, but I also have a paper that's available on the web if you're interested in it, to talk about what the component parts of that legislation. I do think that one of the things that's happened in the aftermath of the failure of the settlement is that there's been a new kind of interest in orphan works legislation. European Union just issued a proposed directive to deal with orphan works. The Librarian of Congress and the Acting Register of Copyrights has written to congressional staffers, to congressional committee chairs to indicate a willingness to engage in some study and recommendations about what to do in the aftermath of the settlement's failure. And so that seems to me to be something that's likely to happen. Whether that would include some components that would, for example, allow non-consumptive research to be made over the library digital copies that Google's partners have now is not clear. In any event, this is fun for me to talk to you about. I think it's the most interesting thing that's happened in my field in my lifetime. And of course, it was a really adventurous use of the class action procedure too. And the question, is it possible to get the good parts of the settlement now that the settlement has been rejected? I think the answer to that is yes, but it really requires some challenging work and some wisdom on the part of Congress, which is kind of hard to expect. Yeah.
Something comparable to a Mann Act with respect to copyrighted work? The reason I ask the question is, you can ship the books to a country that wants to have an interesting business, digitize them there, do all your computation there, ship the books back, copies have them crossed, and perhaps do some serving. You can certainly do all the non-display stuff and ship out results of research, and maybe you decide to let a book search service reside in Bookatopia or whatever you want to say.
So actually, that was more or less Google's strategy with the Google Books project to begin with. That is to say, because they thought they had a sound fair use defense in the United States, they were planning to do all the scanning activities in the United States and even ship books from France, Germany, and Japan to the United States in order to scan them in the United States and then ship the books back afterwards. And there were a couple of lawsuits challenging that as copyright infringement. The scanning in the United States is copyright infringement in France and in Germany, and the court in Germany held that because the copying was happening in the United States, that you can't apply German law to acts that are happening inside the United States, and the snippets that were available in response to German search queries actually fall within the short quotations exception that existed. So Google actually overcame that particular obstacle by only showing snippets and not doing scanning and not having hosts of the corpus in Germany. The lower court in France actually held that the scanning in the United States violated French law. It seems to me that since national laws don't have extraterritorial reach, that will probably be overturned on appeal. But for now, there's a judgment against. I'm sorry?
You can certainly go after the people who are providing the books, the transporters, the violators of the Mann Act. You're transporting books across state lines.
Well, it would be interesting, actually, whether there could be a contributory infringement lawsuit against the German libraries that were, right, because they're not scanning themselves, but they are arguably contributing to infringement. I don't know enough about German law, actually, to know whether that would be something that, because the infringing acts are happening in other places, whether there could be contributory liability by the provider of the books. Yeah.
So when did contributory infringement become part of copyright law? Certainly patent law, but not copyright law.
There's no statutory basis for it exactly. So the way that some people interpret copyright law in the United States is that the statute says that the copyright owner shall have the exclusive right to do or to authorize the reproduction of their work in copies. And so the to authorize language is said to be a basis for contributory liability. So, for example, if I authorize you to make copies of some materials, I haven't myself made the reproduction, but if I have authorized you to do it, then that's a basis on which some liability for me can be imposed. It's a pretty slender thread on which to base the notion that contributory liability exists, but the Supreme Court, in a series of decisions going back to the early part of the 20th century, has interpreted copyright law as not being entirely statutorily bound. Okay? I mean, okay, so here's another example, okay? And this is an example where you'd say, oh, this is a good thing, right? So at the time that fair use became a defense to copyright infringement, it wasn't in the statute. Judges basically made a determination that if a use was fair, then it wasn't an infringement. By the time we got to the 1976 Copyright Act, fair use had become enough sort of an accepted principle that it was put into the statute. But if you had had this kind of rigid notion that you can't read anything into the statute that isn't already there, then fair use would have been something precluded. And, so judge-made interpretations fill out the contours of the law. I would expect that if there was another shall I say, revision of copyright law at some point in the future, that at this point a contributory infringement standard would be part of the statute. And I'll tell you that if the politics remain the same as they are today, it would be worse than if the judges made it.
How can you reconcile the no formalities rule of the TRIPS agreement with any kind of opt-out regime?
So that's the basis of the international objection. Okay, so let me just give you a 30-second vision of this, and thank you for that question. So the Berne Convention is an international copyright treaty that the United States and many other countries are signatories of. Article 5.2, I believe, says that the enjoyment and exercise of copyright cannot be subject to any formalities. So registering, a requirement that you register your copyright or that you put copyright notices on each copy that's distributed in the marketplace are considered to be formalities that violate the international treaty. And this particular part of the Berne Convention was adopted as part of the trade-related aspects of intellectual property rights agreement, that is, say, TRIPS. And so it is an international treaty to which we are bound through 2 different treaties. And the Google's response to the concern that you have to register in order to get your money, right, from the book rights registry, that said that's sort of, that's not Congress doing it, and therefore it doesn't violate the treaty. Now I have to tell you, the governments of France, Germany, and other countries did not find this particularly appealing, and so this was causing actually quite considerable diplomatic stress, because you may remember Angela Merkel actually made a speech about this, and one of the ministers from the German government cared enough about this to come over to the United States and make the pitch before the judge that this was a violation of international treaty obligations. The judge made a statement that he was troubled by these allegations of international treaty violations. He did not find that the settlement, if approved, would violate the treaty obligations. But since he decided he didn't have the power to approve the settlement in the first place, he didn't really have to reach that. But it was one of the set of concerns that he had in denying the settlement.
If the settlement were revised along the lines that you said to make it more palatable and leave out the orphan works, would that facilitate Congress in passing a little orphan works bill to just sort of finish it out?
It's possible. Lots of things are possible. I wouldn't hold my breath about it, but I think that sometime in my lifetime that there will be a way to deal with it. Now, I'll tell you that my sort of more immediate kind of reaction to the orphan work problem is to say, look, Congress may get around to this at some point. We hope they do. In the meantime, I think that you can make a pretty good fair use argument for making an orphan book available, at least to display it, maybe not for download. But if you display the book that you have reason to believe is an orphan, and you are doing it, for example, as a library, then it's a nonprofit purpose for the educational uses. The nature of the copyrighted work is an orphan. You can't find the rights holder to clear the rights. Yeah, the whole work is copied, but there's no harm to the market because there's no market for the work because the rights holder has not been available. So I think that it's possible, even without orphan works legislation, to make a plausible argument for making some orphan works available. And so I'm not going to be surprised if there's going to be efforts to try to address the orphan works problem.
Could there be a nonprofit organization that would do just that?
Yes. Again, you'd have to have a lot of chutzpah. You got to understand that, okay? And you'd want to do it at a state-related
We've got
institution.
people in the valley with chutzpah.
Yeah,
Nonprofits,
exactly.
right?
Yeah, right, exactly. So.
Yeah.
2 questions. It seems, is it true, it seems to me that if Google does nothing, it would be an advantage to Google to delay anything for as long as possible. That's question number 1. Is that right? And number 2 is, how important is the personality, perspective of the Register of Copyrights now that we've finally fixed, now that we've moved from one to not quite another?
Yeah, so those are both good questions. So I'll deal with the question about the register first. So the register, Mary Beth Peters is a woman who worked for the Copyright Office for, I think, 40-some years, for a long time. And she's, I think, the either longest serving or second longest serving register. And this name actually goes back to practically the Middle Ages. It was the name of the person who ran the registry back in the 14 and 1500s. But you know, we like tradition in the United States sometimes. So that's the name of our chief copyright officer. And Mary Beth resigned effective at the end of last year, and there is a search underway right now for a new register, and they've got to have somebody in that role in some respects, and a woman named Maria Plante, who was on the Copyright Office staff for a number of years, has stepped in to be the acting register. I would love it if she got that job. And she, like Mary Beth, is very taken with the idea of orphan works and orphan works legislation, and I think drinks the Kool-Aid about better access to information is a good thing. One of the other candidates, that's the finalist as I understand it, is a guy named Stan McCoy, who is with the U.S. Trade Representative Office, and shall I say, this would be a choice that Holly would be really happy with, and the rest of us would not be so happy with. So, so that's a kind of example of, would we get orphan works legislation under Stan McCoy? Not with the help of the Copyright Office, okay? He would be working with Victoria Espinel on the enforcement of copyrights, and you know, that would be his priority as register. So we don't know yet who will become the register, and obviously that will have some effect on sort of what.
Writing letters?
Yeah, actually that would be a good idea. The Librarian of Congress is the decision maker. He's the decider in this one.
I'm sorry.
Well, it's what it is, okay? So you could write to him, and there are actually others of the finalists that I think might be sympathetic to orphan works legislation and the like would be Rob Kasunik. As I understand it, he's another one of the finalists. But you know, what we can expect out of the Copyright Office going forward really depends on sort of who the next register is. The question about does Google have an interest in delaying? Yeah. Yeah. They have a lot less interest in settling this case. And if the case basically just falls away because they, you know, the publishers lose heart, or they've already spent $15 million in lawyer fees and they don't, you know, it's not such a lucrative business right now that you got an extra $15 million around to go for the next 5 years. And again, the guy who's representing the Authors Guild is in an even more unpleasant situation because he gets nothing unless he wins, and that's going to be many years off unless the case settles. Can I tell you a funny story?
Yes.
This is a good story. So I have a former boyfriend who lives in New York, and he went to an event where the Google book controversy was being discussed. And in the course of that, the lawyer for the Authors Guild started talking about that goddamn Pam Samuelson. And my former boyfriend wrote to me and said, "It made me proud to have known you." In the back.
That's a great story. Going back to the question of privacy, are there laws regarding reader privacy that apply to institutions or organizations like libraries and bookstores? And would any of those apply to Google once it becomes an online bookstore or library, or do they apply to Amazon?
There is actually legislation pending before the California legislature right now about reader privacy. Most of the laws that are in place that protect user privacy are directed to libraries and putting certain responsibilities on libraries. Of course, Google only claims it's a library when it wants to make the public feel good about the settlement, and would say, no, those laws don't apply to us because we're not libraries. So there probably will need to be some either legislation to protect online reader privacy, or there's going to have to be a set of best practices developed if there's not legal regulation, because you know, if we're all operating in the online world now, we have some privacy interests that are worth respecting, and you know, that's actually something that I take very seriously. And you know, there are ways to do it. So the Federal Trade Commission, for example, has been doing a lot to regulate online privacy by saying that it's that you have to have a privacy policy. And then if you violate your online privacy policy, then that's an unfair and deceptive trade practice. And if you don't have a policy, that's an unfair trade practice. And so they can basically kind of nudge people to do certain things, and they've gotten consent decrees in a number of cases. A consent decree is essentially they bring an action challenging the activity, and the parties decide to settle it, and they do it through an agreement that essentially then gets validated by the court, and so it's an injunction, and if you violate the injunction, you can get into trouble. So so entering into a consent decree is a way to try to not only sort of curb some bad activities, but in some sense send out the norms to other similarly situated companies, so that they adopt policies that are consistent with what the Federal Trade Commission has decided is good policy.
The registration of copyright is tied into the sorts of damages that can be claimed, and the outrageously large damages that you were quoting earlier, I assume that all orphan books have been properly registered and so forth, so that the maximum damages apply.
One thing to know is that even though registration is today a voluntary act, you don't have to register, but if you want to get attorney's fees and statutory damages, if you want to be eligible for those remedies in case of infringement, you have to register promptly. And book publishers on average basically have gone through a routine of registration on average, they've been doing this. The major publishers have done it. Now, they'd have to prove it, but you see one of the benefits of having the settlement is that they don't have to prove all that stuff, but they could extract some rent from Google because of that risk of statute. But how would you know how many of the members of the class, right? Again, assuming for a minute that the settlement was going to be, or not, that the litigation, that the class could be certified and the matter was going to litigation. You know, it would be a nightmare to try to figure out how many books actually were registered or not. But it is my understanding that copyright industry groups are different in the degree to which they register, and that book publishers are on the more tending to register than not.
Most author contracts return the copyright to the author 6 months after the book goes out of print.
Right.
In which case the registration may or may not still apply.
I think that's a fair point, and actually I didn't get into the differences of opinion between the Authors Guild and the publishers about sort of ebook rights and what they're each entitled to. Again, if you're interested in it, I've written about that also. So, but that was one of the, that actually in some sense was a possible contributing factor to Google's fair use defense, right? Google could say, look, there's some case law indicating that maybe authors own the rights to ebooks, maybe publishers do. Reversion is one of the reversion right, if the book goes out of print, is one basis on which the copyright, it might not be clear who really owns it, even if the publisher registered it at the time that it was published initially. If the rights revert 5 years later, the registration isn't to the right person. But Google could say, I don't know whether it's the author or the publisher, and therefore clearing rights is going to be a nightmare for us. And so one of the things the settlement did is basically created a kind of dispute resolution mechanism for ebook rights disputes, and did a kind of revenue sharing as between the authors and the publishers. It may actually be that something like that, but you see how that could contribute to the orphan books problem.
Oh, yes. Just one more quick thing, and then go on to other people. Can you comment a little bit about the current situation with archive.org and the Internet Archive, where Brewster Kahle's been out essentially scanning and archiving everything in the universe that he can find using TARP funds. And now that's probably has more scanned material than the Google Books project. And that material is also subject to, like everything else, to copyright, but perhaps a different class, I don't know.
So I think, digitization projects are happening all over the place, and copyright is not being perceived as much of an obstacle by those who are digitizing, as I think the libraries have been more reluctant, partly because they've been in the crosshairs of the publishers in the past. Brewster has actually been very shrewd, really, about his scanning activities, and he's not going after John Grisham novels, which is probably a good idea. So if you kind of stay away from that and kind of go with sort of older works, the chance of the copyright owner coming forward may be relatively modest, Brewster is another one of these examples of people who's got some chutzpah. I once said to Brewster, "You're the bravest man I know," and I still feel that way, kind of. Except you have to say, that the fact that the Google boys were willing to bet the bank on this one just took my breath away. It really did. It was something. I see that it's 5:30. Do we?
Continue on for a while. Okay. Let's take a couple more questions.
So sort of a related question. What are the sort of boundaries or typical processes if an author finds what they think is a copyright violation, but the publisher doesn't want to pursue it?
Well, it will really depend on who owns the rights, who has the ability.
The publisher does, yeah.
But if the publisher has the rights and the publisher decides not to go after somebody, it may damage the relationship that they have between the author and the publisher, and that's certainly a possibility. But I don't think that unless there's a breach of a contractual obligation that's part of the publishing contract, I wouldn't anticipate that there would be any cause of action that the author would have against the publisher in that situation. Cause of action is an ability to bring a lawsuit, sorry. It's hard not to use some legal ease sometimes, yeah.
You mentioned, going back to the international treaties for a second, you mentioned that France and Germany don't like the settlement as it was proposed, but they don't have to like it. Do you think that there's a merit to their claim that it's a violation of the treaty, or is it not?
I'm sorry, I missed the last part of this. So I heard about the France and Germany. Yeah, they're totally opposed to this thing.
Yes, but they don't have to like it. Do you think, from your legal opinion, that there's a merit to their claim that this is a violation of the treaty?
I think it's plausible. I don't think it's compelling. But again, in some sense, it doesn't matter because the settlement fell for other reasons. Now, it does have some potential impact on a legislative solution. right? So one way of sort of thinking about it, okay, you can't do it this way, you have to do it that way. So, you know, let's take extract from the settlement some of the things that are, let's say, reasonable compromises and insert them into legislation. Then the issue about whether or not the international treaties would be violated is something you'd have to confront head on. I will tell you that there's a conversation happening now, both domestically and also on the international scale, about registry systems. Part of the reason that the Berne Convention adopted the rule against formalities was because in the late 19th century, if you wanted to sell your book to several different countries, you arguably had to comply with the formalities of every country, and that was expensive, it was difficult to do, and so it's important to know that every country used to have registry systems, every country used to have formalities, and they only got gotten rid of because of pragmatic reasons, which was that it was too expensive to do. Of course, what we know today is that we have an infrastructure now that would allow multiple online registries and make it easy, register once, register everywhere. And so there is a conversation starting about reinstituting formalities, and even some of the Europeans who have, oh God, this is terrible, have basically come to recognize that that getting better information about who owns what rights to what works is actually something that would be in the larger public interest, and it would probably also lead to more licensing of works because it would be easier to locate the person who actually owns the rights. So again, I'm not holding my breath about this happening soon, but it is actually something that I think is on the table for discussion now in ways that wasn't true in the past. And what that means is also, if we need to change the international treaties because they're not suiting us anymore, we change the treaties. It's not impossible to do. Let's have one last question.
Yeah, the point there being that a registration requirement is not something that would really upset the major lobbyists behind the U.S. Trade Representative, the RIAA and
That's
the
true.
NDAA. They don't mind registering.
That's right. That is absolutely right. They don't care. One of the things that if you spend time in the copyright space, which I don't recommend, I have to say. I mean, I love it, okay? But there are a lot of frustrating things about it, is that there can be some small communities of actors that get really, really exercised about something. And so here's a place where the photographers are really against registration requirements. Because a photographer, on average, may take 1,000 pictures for one that's commercially available, and if you have to register all of the pictures, or even just the commercially successful ones, it's really, really onerous. And you know, unlike books, which have the printing in the printed version, have like who owns the copyright and how to contact the copyright owner information in it. Photographs, on average, don't, and so they were actually among the sort of most strident opponents of orphan works legislation, and they got some traction with members of Congress because they're copyright owners too. Okay, I think we're done. You can come up afterwards and talk to me, okay? Thank you very much.
For more, please visit us at stanford.edu.